In 18th century, England mental illness wasn't treated. It was punished. But many weren't criminals. They were suffering from conditions like schizophrenia, epilepsy, or depression. One of the cruelest laws was the Vagrancy Act of 1744. It allowed authorities to arrest anyone considered idle and disorderly, including those wandering the streets due to mental illness. These people could be whipped, thrown into the Bridewell prisons, or locked in asylums without trial, often for life. The so-called houses of correction were more like torture chambers. People with untreated psychosis or trauma. They were beaten, starved, and forgotten, and kept in total isolation. There was no medical treatment, only punishment. Families were told to forget them. The law had spoken. There were no trials, no mercy. Mental illness was a crime. Change began in the late 1800s. Reformers like William Tuke and Philippe Pinel argued that the MAD were not criminals, they were sick. These early reformers started the push to treat, not punish. But it would take another century for laws to catch up. Even today, the shadow of those forgotten laws remains in how we judge mental illness in courts. The law once called them monsters. Now we call them patients. But history remembers the ones who were punished for their pain. This is obsolete justice, forgotten laws, strange punishments, and the people history tried to erase. Subscribe for more forgotten laws, strange trials, and the madness behind history's justice.